Supreme Court has just released a major decision which could have a profound impact on the midterm election.
Questions are growing about what it will mean for the future of voting in America.
The United States Supreme Court declined to review a major election case involving who has the legal authority to enforce certain provisions of the Voting Rights Act.
The Supreme Court, as it weighs whether or not to gut a major provision of the landmark Voting Rights Act.
Supreme Court has ruled to limit the Voting Rights Act.
A quiet legal mechanism just fundamentally reshaped how elections will be monitored across 7 American states, altering who holds the ultimate power to police federal voting laws. When the highest court in the nation quietly closed its doors to a heavily contested challenge involving ballot assistance rules, it left an immense structural fracture hanging over the entire judicial system. This silent choice bypassed a head-on collision over constitutional authority, but the immediate consequence is a stark geographical divide where federal statutes are actively enforced in some jurisdictions while remaining completely untouchable by ordinary citizens in others. Understanding how a dispute over helping a handful of voters escalated into a massive jurisdictional barrier requires looking closely at the friction points between local state statutes and federal mandates, and why this procedural bottleneck could dictate the flow of future democratic participation. The core of this intricate dispute stretches back through years of legislative maneuvering in the state of Arkansas, where lawmakers implemented a specific statute known as Act 658. Under this rule, any individual who steps forward to assist a voter with marking or casting a ballot faces a strict numerical ceiling, making it a criminal misdemeanor to aid more than 6 separate people during a single election cycle.
An individual cannot assist more than 6 voters in marking or casting a ballot during a current election. Assisting a 7th person triggers a Class A misdemeanor under that state law. The state's rationale for those types of caps that they put in place is typically rooted in election administration, preventing improper influence, and maintaining order at the polling places. By denying review to the case, the Supreme Court left in place a highly contested ruling that came out of the 8th Circuit Court of Appeals. This denial leaves a distinct split in place between how federal voting laws are enforced in the 8th Circuit compared to the rest of the country.
Proponents and state officials defended this restriction through the lens of election administration and security, arguing that caps on assistance prevent bad actors, political operatives, or professional influencers from steering outcomes or exercising undue pressure inside polling booths. State solicitors maintained that limiting repetitive assistance protects voter privacy and keeps the voting process orderly and transparent. However, this local regulation collided head-on with Section 208 of the Federal Voting Rights Act, a broad congressional mandate explicitly designed to ensure that any voter requiring aid due to blindness, physical disability, or an inability to read or write has the absolute right to receive help from a person of their own choosing, with narrow exclusions for employers or union officers.
Section 208 of the Federal Voting Rights Act states that any voter who requires assistance due to blindness, disability, or the inability to read or write may be assisted by a person of the voter's choice, with narrow exceptions like the employer or the union officer.
The friction generated by these competing mandates triggered a direct confrontation when an immigrant advocacy organization named Arkansas United, which routinely supplies bilingual volunteers to assist non-English proficient and Spanish-speaking voters, filed a major federal lawsuit. The organization argued that the state's 6-voter cap directly violated federal supremacy by criminalizing routine outreach and turning away vulnerable voters who desperately needed translation support to navigate their ballots.
They argue that the state's 6-voter cap directly conflicted with the broad assistance guarantees of federal law, stating that it had turned away voters during the 2020 election to avoid criminal liability, so they said that they were not able to operate the way that they wanted and give the assistance that they wanted through their organization because of this voter cap.
When the case initially moved through the judicial system, a federal district court agreed with the plaintiffs, ruling that the federal statute preempted state restrictions under the Supremacy Clause and putting a temporary stop to the state's enforcement. Rather than letting that ruling stand, the state of Arkansas brought the matter before the United States Court of Appeals for the 8th Circuit, setting the stage for a dramatic procedural pivot that shifted the focus away from the ballot box and squarely onto the mechanics of who is legally allowed to sue. Instead of evaluating whether the 6-voter limit itself violated federal guarantees, the 8th Circuit Court of Appeals panel drilled down entirely on a threshold procedural question that completely bypassed the merits of the case. whether private citizens and civil rights organizations possess a legal right of action to bring enforcement claims under Section 208.
The federal district court who reviewed this issue initially agreed with that organization, the plaintiffs, ruling that the federal law preempted the state cap that was put in place, and they said that it violated the Supremacy Clause. Now, in response, the state of Arkansas appealed up to the 8th Circuit, and on review, the 8th Circuit Court of Appeals did not rule on whether the 6-voter cap itself was valid. Instead, they focused entirely on a threshold procedural question, which is, do private groups have the legal standing to bring a lawsuit under Section 208?
In a ruling that sent shockwaves through legal circles, the appellate court concluded that they do not. Relying heavily on strict textualist interpretation and statutory construction, the court pointed out that the text of the Voting Rights Act explicitly empowers the U.S. Attorney General to bring enforcement lawsuits, but contains no matching language granting private litigants or advocacy groups the same authorization under standard legal reasoning. When Congress explicitly names a specific government office to enforce a statute, courts frequently infer that other parties are intentionally excluded. Consequently, the panel ruled that enforcing Section 208 is strictly an executive branch responsibility, slamming the courthouse door shut on private groups.
The 8th Circuit panel ruled that they do not, so they ruled against the organization. The court's argument relied heavily on strict textualist and structural interpretation of certain federal statutes. They pointed out that the Voting Rights Act itself explicitly has textual language that grants the U.S. Attorney General, and it gives them the power to bring these types of enforcement lawsuits, but it does not have the same language allowing private citizens to do the same thing. So under standard statutory construction, if Congress explicitly names one party to enforce a law, courts generally assume that Congress intended to exclude others. So since they left out a private action or allowing these types of guarantees for organizations, the court here found that the text simply does not support them bringing this type of lawsuit. Therefore, the 8th Circuit concluded that enforcing Section 208 is strictly the responsibility of the executive branch, not private litigants like the group here, Arkansas United.
This narrow interpretation sparked sharp dissent from within the judicial ranks, with opposing judges warning that the decision violently upended decades of established legal practice. Legal historians and civil rights advocates pointed out that for over half a century, the overwhelming majority of voting rights enforcement across the country had been initiated by private individuals, nonprofit associations, and advocacy coalitions, because the Department of Justice operates with limited resources and cannot possibly police every polling place in America. Chief Judge Colloton of the 8th Circuit also dissented, arguing that the panel's stance sharply departed from historical norms and the broader consensus across the federal judiciary. This deep internal division reflected a wider national fracture, creating an undeniable circuit split. While the 8th Circuit barred private claims, other appellate courts, including the 5th Circuit and 6th Circuit, had long permitted private plaintiffs and organizations to move forward with Section 208 lawsuits, establishing a fragmented landscape where federal voting rights suddenly depended entirely on geographic boundaries. Desperate to resolve this chaotic split, Arkansas United petitioned the United States Supreme Court to review the case, warning that leaving the 8th Circuit ruling intact would fracture the American electoral system into a patchwork of unequal protections. The petitioners argued that stripping private litigants of standing effectively defanged the statute, leaving vulnerable voters with disabilities or language barriers entirely defenseless if federal prosecutors chose not to intervene. Yet despite the glaring contradictions between different federal circuits, the Supreme Court ultimately declined to grant certiorari, choosing to leave the controversial appellate ruling completely undisturbed. By refusing to take up the case, the highest court in the land allowed the 8th Circuit doctrine to remain firmly entrenched across 7 specific states: Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota. The immediate practical fallout of this denial is profound. In those jurisdictions, individual citizens and civil rights groups can no longer independently challenge local restrictions or sue to protect ballot assistance guarantees under Section 208, leaving enforcement exclusively in the hands of federal authorities. Meanwhile, the restrictive Arkansas ballot assistance cap remains fully operational and enforceable. As election cycles approach, the legal avenues available to voters have narrowed dramatically depending on where they live, cementing a controversial procedural hurdle that fundamentally alters the landscape of American election oversight.